Hi, I'm Carol Carini from Billabong Marketing, and today I'm talking with John Farver from Farver Law Firm in Bellevue, Washington. John has 22 years of experience in the field of bankruptcy and is an expert in the industry. Now, John helps clients tackle the confusing and sometimes daunting path through bankruptcy, and today he'll be talking about Chapter 7 and what makes you qualify for Chapter 7. Hi, John. How are you?
Carol, fine. How are you?
Good, good, thank you. Now, we were talking in the last video about what bankruptcy was, and now we're going to talk about Chapter 7, and there's a couple of different chapters, Chapter 7 and Chapter 13, but explain to us about Chapter 7.
Okay, Carol, you're right. We talked yesterday about Chapter 7 and the Chapter 13. Between the two of them, the Chapter 7 is what's normally regarded as or explained as the straight bankruptcy, complete liquidation of a debtor's non-exempt assets in order for them to discharge all of their unsecured debt. We'll talk about the Chapter 13 in the next video, but that is a wage earner's repayment plan.
Mm-hmm.
So, and we'll get into more of that detail next. But in a Chapter 7 is what everybody normally thinks of as a bankruptcy. You go into bankruptcy owing a lot of money and you come out owing nothing as far as your unsecured debt goes. What happens in a Chapter 7 bankruptcy is that you as a debtor basically give title to all of your non-exempt assets to a Chapter 7 trustee, who then has the obligation to sell that property and take whatever money is made from that property and pay it to your unsecured creditors. And whatever they get on their pro rata basis, that is all they're going to get from the bankruptcy. In general, it's been my experience, and it's the intent of the statute, that most people don't have any property to be sold. And we'll talk about that a little later as far as exempt property. But in a sense, what the code requires you to do is list all your property, give theoretically title to that property to a person who's appointed by the court to be a trustee. It's a bankruptcy attorney whose job it is to oversee Chapter 7 bankruptcies. To begin with, you have to qualify for Chapter 7. Until 2005, if you were insolvent, which meant in general, if you could not make your monthly payments with your monthly income, you were considered insolvent, and then you qualify for a Chapter 7 under most circumstances. In 2005, the Congress changed the law and made it harder for people to file a Chapter 7 by putting income limits into the Chapter 7. And if you made more than those certain income limits, then you would disqualify from filing Chapter 7 and would have to file under another bankruptcy code provision, primarily a Chapter 13. That is, and the way you determine whether you qualified or not is through what's called the means test. In the means test, you determine what your income has been for the last 6 months, multiply that by 2, and that shows your annual income. You compare your annual income to the chart that the bankruptcy court has determined. And what they've determined is, and they use the IRS determination, what is the mean income of a family of your size in your community. If you make more than that, then you don't qualify. Now, the means test can be very simple if you make less than the median income. In Washington State, and this is just an example, every state is different, every area of the country is different, the median income for a single person is about $53,000. And the way you determine that is you take your last 6 months' income, gross income, and multiply that by 2 to make it a 12-month, 1 year's worth of income. And the reason the code does it that way is to allow for somebody who may have had been making excellent money until they lost their job, to not have to go back the past year, because that would include income when they were making a lot of money up until they filed when they weren't making very much. So you only look back the past 6 months, and then you multiply that by 2. So if you got laid off in the last 6 months and you made 0, and you can multiply that by 2, and you still were 0, even if you'd made $200,000 a year before.
So that seems pretty fair.
Yes, it does. Relatively fair, and so you get the I don't know if you want to call it an advantage, but you get the advantage of taking into account only your most recent income. If your last 6 months' income divided by 2, or I mean multiplied by 2, is less than, in this case, if you're single, $53,000, you automatically qualify for a Chapter 7.
Mm.
If your income under that determination is more than the median income, say you've made more than $53,000, then you continue on the test, and the test has many questions, and each one of those questions allows you to deduct a little bit more from your gross income. Question number 2 would be, do you live in a house or an apartment? And it will allow you to take what the IRS has deemed reasonable costs for living in an apartment or a house during the past year. You get to deduct that amount from your gross income and see if then it becomes less than $53,000. If it doesn't, you go on to question number 3 that deals with cars, and question number 4 and 5 and 6 on down the road, each one dealing with a different cost, and you get to subtract that cost from your gross income, and hopefully by the end it'll be less than $53,000. If it isn't, again, then we start looking at other chapters of the Bankruptcy Code. In that process, and this is one of the main reasons you need to get good legal counsel when you're deciding to file bankruptcy, because you need somebody who knows the ins and outs of the means test and is able to maximize your deductions to make sure that you get below the median income for your family size and your community so that you'll qualify for a Chapter 7. Once you've qualified, then you start the bankruptcy procedure, and that includes disclosing all of your assets, and you can do that in chunks in certain categories such as furniture, household appliances and electronics, automobile, home, and you don't have to list each individual item of your property, but within those constructs, say your furniture, you simply put down furniture, and then you set the value of that furniture, and it has to be a fair value, but it is not resale value at a consignment shop, or it's a value that you would probably get if you had a yard sale. Because in effect, if you listed your property and the trustee decided to sell all your furniture, which they won't, they would hold a yard sale and sell your furniture, and so your values have to be reasonable, but they would have to be what you would pay for that same property at a severe discount sale such as a yard sale. So you list all of your property and you list the value. Again, it's nice to have an attorney involved at that time. The attorney will know in general, as will the trustees, what your furniture is worth in that area. So once that is taken care of, you list all of the exemptions. How much of that property is exempt? In general, the exemption allowances, either through your state code or the federal code, are relatively generous. So most people keep their furniture and their clothes and their appliances, basically everything they own. Your assets include savings accounts, checkings accounts. Those have also an exemption limit, and if you're below that limit, you keep all of that property. If you're above that limit, the trustee then gets to decide whether he is going to sell that property and give you the exemption amount in cash, and take whatever he gets above the exemption amount and uses that to pay your creditors. I've got to point out that, at least it's been my experience in the last many years of doing this, that most ordinary consumers don't have any furniture or electronics or such that are above the exemption limit. Again, a good attorney who can determine what the value is and whether or not it's exempt under the code is a nice thing to have.
I was just going to say, there has been, actually online, I've seen a lot of people saying, how can I do this myself? And for me, that just seems unbelievable that someone would want to go through something so serious and try and do it on the, do it themselves, or also do it on the cheap, because this is not an easy process, and that's why people like you work with people to get them through this process. But I'm surprised that I see so many people saying, how can I do this myself?
Well, and I agree. And I must admit that I'm a real do-it-yourselfer anyway. I like to do things around the house myself. I like to work on my cars myself. But there's certain things that I just won't do. And in my experience, filing bankruptcy, especially if you have difficult questions, is pretty hard to do by yourself. And I'm not saying you can't, because certainly people with very simple debts and very low income can probably go in and do it themselves. But if you want to make sure it's done and done correctly and done easily, the price for hiring an attorney to do it is not high enough to justify, in my mind, attempting to do it on your own. There are a few pitfalls that you don't want to fall into, and in general, oftentimes you end up not getting the benefits that you wish you could because you just don't know how to do it.
Right.
Again, and one of the things is my property exempt or not? A lot of property, if you took at face value, you don't meet the exemption, what do you do then? Well, it's certainly legal and legitimate to convert non-exempt assets to exempt assets. And most attorneys who are knowledgeable about bankruptcy law can assist you in doing that. So oftentimes you could lose property that you wouldn't if you just had somebody who could say, listen, it's not exempt now, but we can convert it to exempt property by doing this, this, and this, and following these rules. Again, to make sure you maximize your exemptions and maximize the amount of property you get to keep, I would suggest and strongly suggest that you find an attorney who's experienced in bankruptcy and does it for a living and can assist you. The cost of filing a bankruptcy as an attorney, at least in the area that I practice, is not extremely high, and chances are you'll make that money back by making sure that your bankruptcy is done and done correctly.
Great. Well, thank you, John. That's some great information about Chapter 7. On the next video, we're actually going to go into Chapter 13 and talk a little bit about that.
Okay, that'd be great.
Thank you. Thank you.
Okay, look forward to talking to you.
Thank you. And everyone, if you would like to contact John Farver, you can go to farverlaw.com. And if you want a free consultation, you can go to farverlaw.com/free and or call him. The phone number is on the screen now. I'm Carol Carini, and we'll see you next time.